last week we really had a rollicking and informative session with Joe Berlinger, filmmaker and producer. And before that, Bobby Friedman was our guest. And we certainly learned a lot from him and his great history in producing documentaries and series. So tonight we're very fortunate to have my partner, Neil Rosini. Neil Rosini has been helping nonfiction television and film producers achieve their journalistic ambitions without legal mishap for almost 40 years, starting with the first episode of Frontline. He taught entertainment law as an adjunct professor at NYU Law School for 7 years. He still teaches a legal workshop on documentary filmmaking at DC TV. Neil speaks and writes frequently on these topics related to copyright and fair use, rights of privacy, publicity. Really excited to present him tonight. I have the pleasure of co-authoring the Legal FAQ column of Documentary magazine with my colleague, Julie Angel. So without any further ado, let's get started. Neil, thank you for being here tonight. I want to kick off the questions with a hypothetical that could be real, because a lot of folks are looking into the last pandemic. About 102 years ago, the 1918 Spanish flu. And there's this hypothetical filmmaker out there who has been working hard and trying to trace a parallel between COVID and the Spanish flu. And they have in their documentary, they were able to go through some archives and pull out some video and images from third parties to put into the documentary that they're producing. The hypothetical filmmaker has wondered, feels confident that based on the fact that that was 102 years ago, that these images must be in the public domain. We get a lot of questions about the public domain. So Neil, maybe you can respond to whether or not our hypothetical filmmaker is in a safety place.
Most everything that's been created for the last 100 years is not in the public domain. It's a relatively small portion of works in general. But anything that was published in the United States prior to January 1, 1925 is in the public domain. You can be confident about that. Beyond that date, it's a process. It requires research of the Copyright Office sometimes. It requires more information about whether the necessity of having a copyright notice during a certain period was observed. It's difficult to determine whether things are in the public domain, except for print articles and photographs first published in the US before 1925. That's in the public domain. Starting January 1, that year will go up to 1926 and so forth.
Is there a rule of thumb that filmmakers can look to? I know that's easier said than done because there are lots of exceptions, and the copyright law has been changed over the years and it can be complicated, but is there any rule of thumb as a starting point?
Yeah, that's about it. Anything published in the US before 1925. That's the rule of thumb.
Great. Dan?
Hey Neil. Well, I really appreciate you joining us tonight. And Stephen, I really appreciate you bringing Neil into this really important discussion that we're having about the law and what's appropriate as far as fair use and copyright for documentary films. And I kind of want to get right down into the sort of fair use area, because it seems to be that it's this gray area that a lot of people have a mass amount of confusion with. Whether it's using photography or using a motion picture or a video image or using a piece of music. And I would love to have you kind of clarify how people can sort of navigate the shades of gray or get out of the shades of gray, and what makes sense and what doesn't make sense.
Well, let's start with a little bit about what copyright is and why it exists. It exists for the purpose of encouraging creators to create. And the idea is to give them an economic incentive to do that through this monopoly of rights of reproduction and distribution and public performance and so forth. So fair use is a bite out of that monopoly. And it's really intended as just a bite, because if it were too much of an exception, it would defeat the purpose of copyright, just to give that economic incentive. So the starting point for fair use is that its application is relatively limited. And whether or not a particular use is a fair use or not depends on a balancing of a number of factors. But I think, just taking a step back, it's best to look at fair use as an assessment of risk. And at a certain end of the spectrum of risk, you know that something's a fair use, and it fits all the categories. There's no doubt about it. And then at the other end of this spectrum of fair use, you know it's not. It's impossible to be a fair use. Most documentary producers are trying to fit somewhere within that risk zone. And my job, as I see it, or the job of lawyers, is to try to push the use toward the safer end of that spectrum. And there are certain ways of doing that.
For example?
Shall I go on? Okay.
Yeah, please.
Well, what I like to suggest to documentary makers is that they concentrate on 5 principal questions to figure out whether a proposed use is a fair use or not a fair use. So the first question is, why is this clip? Let's talk about clips for the time being. We'll come back to photographs and music in a second. But let's talk about clips first. First question is, why is this clip being used? And the more rigorous a documentary maker is in answering that question, the better, because fair use will be easier to qualify for if there's a rigorous purpose and it's kept to, and there isn't, you don't go beyond it. You limit yourself to the rigorous purpose. So, for example, if you want to show that a late night host is a genial fellow, you don't have to show the 5 best jokes he's told in the past year. If your rigorous purpose is to show he's a genial person, you can do that in just a few seconds, and not necessarily even the best joke he's ever told, or the most interesting guest he's ever had. The next thing I like to ask documentary makers to think about is the function of the clip in the documentary different from the function in the original setting? And this is sometimes known as the transformative test. You're taking a clip and you're giving it a new meaning, you're putting it in a new context, you're giving it a historical perspective, or to support an argument. In short, to put it into a context of comment and criticism, that's far more likely to be a fair use than most other types of uses. Next question is, what's the minimum you need to take to satisfy that rigorously defined purpose? That's why it's so important to define your purpose, because only then can you determine what's the minimum you need to take to satisfy that purpose. The less taken, the better. And this is not only a quantitative test, that is how many seconds you're taking, but also a qualitative test. Are you taking the best joke, the best part of a film, most exciting part? That's fair use doesn't smile on that, if your purpose could have been served by taking a less critical part. Next question is to bear down a little bit more on that question of whether you're putting the clip in a context of commentary and criticism. Fair use smiles on that. And the way to do that is to put the comment or criticism before the clip or after the clip, but even better, to put it over the clip, so that the entertainment value of the clip is diminished, and thereby you make your use transformative. And lastly, the important question is whether the borrowed clip is there in your documentary principally to make your documentary more entertaining. If it is, that's not a good thing. The entertainment value of your documentary should come from your documentary or from things you've licensed, but not from things that are used on a fair use basis. It's not its purpose. Fair use is there to support comment and criticism. It's not there to make your documentary more entertaining. With regard to photos, let's talk about that. Photos are relatively, still photos, particularly from professional photographers, are relatively difficult to justify on a fair use basis because it's almost impossible not to take the entirety or the best part. And on top of that, to simply appropriate photos, to borrow photos, is going to have a hard economic effect on the photographer who depends on that licensing for a livelihood. And fair use just doesn't smile on any of that. With regard to music, music is similarly difficult to justify on a fair use basis, unless, of course, this would go for photos too, unless it's the very object of the comment and criticism. Somebody's talking about a piece of music and saying in the first 8 bars, this is what the composer does, that's going to lend itself to fair use. But to have a piece of music laid in for effect, to set a mood, or even to bridge different sequences without permission and without paying for it, that's a much more difficult row to hoe with fair use.
So Neil, one of the portraits, a framework where we were able to analyze the factors, the fair use factors, was surfaced some years ago with a 16-hour documentary about Elvis Presley. It was called The Definitive Elvis, and the project had plenty of footage from Elvis Presley TV shows, his performances, that were fairly extensive, and they were not aligned with commentary or narrative, but certainly the entertainment value was set forth within it. Now, those performances were only about 10%, however, of the entire project. The plaintiffs, the owners of the video and various elements, assets of the Elvis Presley estate, challenged that documentary and took it to court, and that was one of the knockdown drag outs where fair use was at stake. I was wondering if you could go through the analysis of the factors that you just mentioned and discuss how they apply to an actual case like that.
Well, I'll try to be a little more concise rather than go through each of those points. But if somebody producing a film about Elvis Presley had come to me, I would have said, you really have a choice between 2 types of film here. Type number 1 is where it would be largely the entertainment value of Elvis Presley's performances that are going to be the value of the documentary. So your audience is going to be invited to sit back and enjoy the performances. That's one type of documentary. And that type of documentary requires licensing. That's not going to be defensible by fair use. There are just 3 categories into which a borrowing can fit. One is licensed, one is fair use, and the third one is infringement. And if it's not licensed and it's not fair use, all that's left is infringement. The other type of documentary that could have been is a documentary that's more based on comment and criticism relating to the career of Elvis Presley. And parts of his performances could be taken as historical markers for that purpose. Short parts, but not so much that the audience is invited to sit back and enjoy the performance. It's going to be more staccato with insofar as using Elvis is concerned, and more reliant on witty commentary and criticism, either in the narration or in interviews. It's a different type of documentary. That type of documentary is highly defensible by fair use. there are certain points along that spectrum of risk in between those two poles. But those are the two principal ways you could produce that.
So now I have a hypothetical, and this one is about a project, a documentary retrospective of some of the great women comedians. In this hypothetical, the filmmaker profiles Lucille Ball, Carol Burnett, and Gilda Radner. For Lucille Ball, the filmmaker wants to showcase her physical comedy. For Carol Burnett, it's the way she works with props, like her wigs. And then for Gilda Radner, it's her performance in parodying news people that she would do on some of her characters on SNL. The clips that they use are really focused on to those particular traits, those character references, as opposed to the more broad or more popular. So the clips that they used were 5 to 7 seconds long in this hypothetical. Maybe the longest one is 10 seconds. There's narration, there's commentary, and they're not using the very heart of the most of these clips, and they're not the most famous of clips for either Lucille Ball, Carol Burnett, or Gilda Radner. Now, this hypothetical filmmaker is asked whether or not she should go and license these clips, which has its own challenges and expense, or whether or not she might be able to avail herself of the fair use defense under the Copyright Act.
Well, you come from a very good starting point with that hypothetical, because the filmmaker has identified with some rigor what the purpose of each of those borrowings is going to be. In the first instance, to show physical comedy; in the second instance, to show wigs; and the third instance, to show satirization of newscasters. So that's a good starting point, because then one is not tempted to, say, show the best 5 skits of Lucille Ball. Instead, you can take a relatively small portion of one skit and show Lucille Ball manipulating objects to show, or falling, or whatever shows physical comedy. With wigs, that's kind of obvious. You could show a montage of wigs. You don't necessarily even have to use sound to show wigs. And the third instance, satirization of newscasters. Again, it's a relatively defined purpose, and it can be a relatively limited taking, all of which is conducive to fair use.
Dan?
Oh, and one other thing, you mentioned the duration of the clip, 7 seconds or 10 seconds. The duration is important because you want to use the minimum you absolutely need. But there is no magic number. It's not the case that if you take 10 seconds or less, you're fine, or 20 seconds or less. That doesn't exist. It's a more complicated balancing of these factors. What's your purpose, and what's the minimum necessary to satisfy that purpose? So it could be 10 seconds, or it could be 3 seconds.
I think our hypothetical filmmaker's in good shape then.
Huh. I'll have to see it, but sounds like it.
Neil, so I'm a hypothetical filmmaker, and I come to you and say, I want to do a documentary about B.B. King, right? So how would you advise me about obtaining, do I need to obtain life rights? Can I, because he's a public figure, can I just go ahead and do it? You know, how would you also advise me about dealing with his estate and all the music involved, the publishing, the original recordings, et cetera, et cetera?
That's going to be a long meeting. Well, first, with respect to life rights, documentary makers are in the same category as print journalists. So there's a great deal of protection from the New York Times to explore and publish what's newsworthy, and you don't need permission to publicize what's newsworthy. So a biography of a musician, particularly a famous one, is going to be newsworthy. You don't need permission. It's helpful to have permission because then you get access to clips and archive. You might get exclusivity. You're not going to be bad-mouthed by the family or by a surviving musician. So there are certain advantages. And on top of that, to get permission will assist in getting errors and omissions insurance, and will make the ultimate network or the other platform happier than if you didn't. With regard to how you clear music, in existing recordings of music, there are two copyrights. There's the copyright in the composition, and that corresponds with notes on a page. And there's a copyright in the sound recording, and that corresponds with a performer's interpretation of what was notes on the page. The notes on the page composition copyright is usually owned by music publishers. The second copyright, the sound recording copyright, is usually owned by music labels. So you have to go visiting each of those sources to clear the necessary rights, if that's unless it fits within fair use, which is highly unlikely in the case of a music biography, unless there's just staccato clips that aren't particularly entertaining. Was there a last part to that question?
Well, I guess the follow-up would also be that it's the conundrum that I face and a lot of producers face and filmmakers face is, especially with music, is trying to budget for it. Because it's so hard, because what people want to charge, it ranges. It could be $500 for one recording, and it could be $50,000 for another. You know, and how do you even start a project before you sort of figure that out? You know?
Well, that's exactly the point, that you can't start a project until you figure that out. So you can't wait to the very end and then go off to the publisher and the music label and ask what it's going to cost, because it could be prohibitive. Or you could find they're not interested in giving you a license at all. That's something that has to start right up front.
I recommend that the filmmaker contact a qualified, experienced music supervisor from the get-go. There's at least one of the great music supervisors watching tonight, Jonathan McHugh, saw him, and they will give you a strategy, outreach, use their relationships, and work within a budget to try and secure the various copyrights, whether it's the underlying song, the recording. But relationships with the record labels can really be helpful if you need the particular master, and a good music supervisor can point you in the direction of other recordings that may not be the most popular recording, that can be a lot less expensive, and can show you some alternatives as well. But that's there are many things to consider at the onset of a project, and you're especially when you're looking at doing a documentary featuring about where an artist is your subject. So your ability to license the music, both the song and the recordings, is very, very much is key to that. So one of the things that we're seeing today, Neil, is a consciousness of social justice documentaries, of David and Goliath, where documentarists are like journalists, and they are shedding light on social issues, things that and kickstarting conversations, things that need to be viewed and discussed. The challenge, however, is that oftentimes the Goliath has a very deep pocket, and can use the laws of defamation as a way to push back against aggressive documentary filmmaking. What strategies, what considerations do should a filmmaker view, and what strategies should they undertake when getting started with a documentary that has sensitive information that could tweak some sensitive feelings and cause financial damage to a Goliath.
Well, Goliath can come in the form of a big company. It can come in the form of a celebrity. They come in many guises. And fortunately, in the U.S., the law favors journalists, and that includes documentary in defamation cases. But as a point of departure, truth is an absolute defense. But who knows what truth is in many instances? It's a little hard to be absolutely certain about truth almost across the board. So the First Amendment in the US has been interpreted to permit journalists a backup in case what they publish turns out not to be true and is defamatory. And by defamatory, I mean it injures somebody's reputation, either a company or a living person. You can't defame dead people. So the First Amendment, though, still requires that when a journalist publishes a defamatory statement, that is one that injures reputation, the journalist has to have good reason to think the statement was true at the time it was published. Now, how do you do that? You do that by corroboration. You do that by documents, by interviewing witnesses, by looking at contemporaneous news reports. And the law requires a kind of common sense balancing of the degree of corroboration that's necessary. So for example, if you have lots of research time, if you're not doing the 6 p.m. news every day, you're expected to do more corroboration. If the social importance of what you're reporting about is greater, you're perhaps getting a little break as to how much corroboration you need. The number and quality of your corroboration, your corroborating witnesses or documents is important. The more injurious the statement, the more sources you need. And also you got to take into account, of course, the degree of harm of the statement. So in that situation, the David and Goliath situation, one has to be very careful to corroborate fully and also to frame the statements in the documentary to track very closely what you have corroboration for. Don't go an inch beyond the material you've got that stands behind it. And that's sometimes a very time consuming process to compare narration or even to compare the statements by interviewees, because the journalist adopts the statements in the doc so that even though it's not coming from narration, if it comes out of the mouth of an interviewee, it's still adopted by the journalist. And if that interviewee is not sufficient corroboration all by himself or herself, and often they're not, if you take those balanced factors into account, you still need more corroboration before you can run it.
Excellent.
Hey, when I've been working on some prior projects, I've noticed that there are multiple, video and film stock companies that represent that they have the exclusive license on certain materials, and then I've seen that has replicated itself with different companies. And I guess the question would be: is that how much of it is the filmmaker's responsibility to verify that the place you're licensing the clip from, that's a third-party company, actually has the actual rights or exclusive rights to that clip?
Well, that's a good question. Generally speaking, anybody who infringes copyright is simply held responsible. It's a no-fault arrangement. However, the amount of damages available to somebody whose copyright's been infringed will depend on the degree of of knowledge and intent by the user. So for example, if you go to the wrong source, but you have really good reason to believe that archive actually either owned the copyright or was an agent of the copyright owner, and it turns out not to be the case, you, the documentary maker who borrowed that material, was still responsible for copyright infringement. But there is a category called innocent infringement for which damages are just a few $100. The problem is the legal defense.
Yeah,
That's one great reason for picking your archive with care.
Wanted to ask you a question that we frequently get asked about E&O insurance, errors and omissions insurance, something that every documentary filmmaker has to know about. So why don't you tell us about it? What does it do? How does one secure it? And what role do we as attorneys play in that process?
Errors and omissions insurance is, generally speaking, a prerequisite to getting a distribution deal or to getting exhibited by a network or a platform. And what it does is that it insures against errors and omissions in three principal areas: copyright, including whether or not you make a bad call on fair use; defamation, injuring others' reputations and not, that is whether or not you have the proper corroboration. If you're sued, you could still use insurance to pay for the defense. And the third area is rights of privacy. It also covers other IP infringements such as trademark infringement and the like. But you go to a broker, generally speaking, an insurance broker, and the broker in turn works with various carriers who issue the insurance. The carrier generally requires an opinion letter from an attorney on fair use in particular, sometimes an opinion letter that's broader than that, but that's relatively rare. And the more careful you've been in collecting appearance releases, location releases, materials releases, and corroborating your material, the more likely A, you'll get the insurance, and B, you won't pay an inflated premium for it if you do get it.
So when a filmmaker comes to us with the project, is it a situation where we review the content and it's a no, or what is the practical counseling role that we play in reviewing and counseling on the content that we see?
Generally speaking, I think the lawyer's role is to help the journalist or the documentary maker achieve his or her ambition. And there may be some discouragement along the way as to whether or not you can use a 15-minute clip from Elvis or not. But our job is to try to help the documentary maker achieve that vision within what the law permits. So I think the lawyer's role is generally a positive one. And it is not simply to say no. It should almost always be to say yes, but here's how you get to yes. And it's part of a give and take. You want to talk to the documentary maker. It's not just where the lawyer says this is it, do it this way. It's a give and take as to what still fits within the scope of what the documentary maker wants to do, and overlaps with what the law permits.
I would actually like to know, when does a project, a concept, an idea become copyrightable? If I come up with a treatment and I'm writing, a 2 or 3 page treatment about B.B. King, the documentary, whether it's a feature or a series, but it's just in treatment form, when does that become my copyright, an idea, or I have to get something onto film, for it to become copyrightable?
Well, copyright doesn't, to be technical about it, it doesn't protect ideas at all. It doesn't protect concepts. All it protects is the expression of ideas. So if you have a 2-sentence description on a page, that's pretty much a concept. It's a fact. It's probably not going to be protected by copyright. If you get into 3 to 5 pages, even 2 pages, even 1-page single space with a lot of detail, you can cross that line, you can cross that threshold, and that can be subject to copyright. Once you get more developed, if you've made a proof of concept film or the like, certainly that can be copyrighted. Text of all kinds, films of all kinds, anything that's a tangible medium of expression, other than just talking. That's not a tangible medium of expression.
So if I've made my film and I have a 90-minute documentary and it's going out into the film festival circuit, but I've just never thought, I'm a first-time filmmaker, and I've never thought about actually copywriting something, right? Copywriting my film, is it automatically copywritten at that point?
By copyrighted, I think what you mean is it protected under the law of copyright?
Correct.
The answer is yes. Copyright attaches to works at the moment of creation. There was a time when you had to register to get a federal copyright. That time is long behind us. Copyright protection attaches at the moment of creation. Registration of copyright does offer benefits that simply creating something doesn't. For example, attorney's fees might be available in a lawsuit if you win, where they wouldn't be available if there wasn't a registration. And
statutory damages.
Certain types of damages are also available only if you register the copyright.
Understood. David?
So I'd like to get to the Q&A, but before we do, let's talk about personal releases, because on occasion, filmmakers will come to us with a great project, but somehow they were so excited they didn't get releases from some of the best subjects that they had. Tell us about the role of personal releases. What should they include? Why are they important for distributors, E&O, et cetera?
Well, let me tell you why they're important, and that will take us to what goes into them. The first reason they're important is because, going back, a distributor or a network is likely to need them, require them, as part of the delivery requirements. You might not get your last payment until you're prepared to deliver a set of appearance releases, at least for your principal characters. Secondly, for errors and omissions insurance, you'll be filling out the application, and the question will be there. Do you have appearance releases from everyone on the film? And if not, why not? And sometimes you can talk your way out of it if you miss one or two, but that could affect the premium. It could result in an exclusion from coverage. So if you have appearance releases, you're better off. And thirdly, an appearance release, if done properly, and virtually all of them are, leaves no doubt as to the scope of use that's anticipated and being permitted. So it doesn't allow someone to say after the fact, hey, I thought this was going to be shown on Instagram for a day, and here it is on 60 Minutes, I've been duped. The appearance release will lay out the scope of use, so it avoids that kind of question.
Great. So why don't we turn it over to our audience and see if there are any questions for our guest speaker, Neil Rosini.
Great. You guys have put some great questions in here, so let's jump in. I have one from Ken Rabin. I've been told it's a good idea to credit sources or copyright holders for material you have fair used, separately from those you've cleared, such as under an additional sources list. I know fair use clips must include credit, at least at the end of the film. Does it need to be, or should it be, segregated from credits for cleared clips?
That's a good question. And I think the more important thing is to be clear that you're not implying that sources from which you obtained clips used as fair use gave you that permission. So if you had two lists, one list might say the following sources, well, courtesy of would be a typical way of describing sources from which you got permission. And you don't want to say courtesy of with respect to fair use clips because nobody gave you that courtesy. So instead you would say something like additional material obtained from, and then you'd make that list. So the short answer is yes. I recommend two separate lists.
This is from Tom Putnam. How do you feel about interview subjects verbally agreeing on camera to appear in the film rather than signing a release in a pinch?
In a pinch, it's better than nothing. But the problem with verbal releases is that they're not going to be nearly as detailed as a typical appearance release. So that the questions that a written appearance release avoids won't all be avoided with a verbal release. It's better than nothing, but it's not as good as on paper.
This one is from Charlie Londono. Since fair use is a USA copyright concept, although I understand Israel and South Korea have their own forms of fair use, how do you advise clients with licensing issues in connection with worldwide exploitations of documentaries?
It's a funny thing that for most purposes, if you clear the legal standards in the US, distributors and networks and platforms and even E&O insurers are apt to accept that as sufficient for worldwide coverage. And one reason is in countries outside the US, damages are less. So even if you're caught, it's not going to be as ruinous. But another reason is that a lot of countries tend to observe the rules of the country of origin. They follow the rules. So the short answer is it's usually not a problem if you satisfy standards in the US. It's not saying that it can't be a problem, but practically speaking, it generally isn't.
From Natalie Bartello, if you're trying to use a clip from a game show and cannot identify the individual or guest, who do you go to get permission to use their likeness? If someone controls the rights to the game show format or holds the trademark rights, do they also control the rights to the old clips of the game show's guest appearances?
I would say, generally speaking, that a participant in a game show is going to be signing a release that permits all uses of the video captured by the producers of that game show. So if you get a license from the game show, chances are you're going to be covered. But sometimes you don't even need that extent of permission, because remember, the First Amendment is very favorable to journalism. And if you are covering something of newsworthy value, you don't absolutely have to have a release from everybody in the picture. The New York Times doesn't go out and get a release from everybody it reports on. And doc producers are in the same category. There are advantages to getting releases, but if what you're reporting on is newsworthy, and that would include historical retrospectives of game shows, if that's what you're doing, you don't necessarily need a release from everybody in the film.
This is from Kirk Schroeder. When networks or distributors want an opinion or some confirmation from the documentary filmmaker's lawyer, how do you approach that from the lawyer's standpoint?
A confirmation of compliance with the law, that kind of thing. Well, I'll assume that's what you're getting at.
It's not clarified there, but maybe if you want to clarify in the chat box. I can move to another question. We'll come right back to
let's
that
come
one.
back to that. Okay.
Let's see. Could you talk about Hipaa, H-I-P-P-A, and whether there's any leeway in applying fair use?
I may be wrong, but I think that Hipaa and fair use are on two separate wavelengths. And Hipaa is largely a set of, as I understand it, I'm no Hipaa expert, but I understand Hipaa is largely a set of criteria and attaching to penalties having to do with disclosure of medical facts, mostly by people in the medical profession and in healthcare. Hipaa doesn't have that direct relationship to documentary making, except documentary maker may find that the healthcare institution or the doctor is not very happy about sharing information about an individual's health record for that reason, because they're concerned about running afoul of HIPAA.
This is from Stephanie Jenkins. There's conventional wisdom within the archival community that you can't claim fair use for some material and licensed other from within the same archive. Is there anything to this?
Yes, I understand that question. Some archives, if you read the fine print of a license, will say that in accepting this license, you agree not to publish anything else from our archive essentially on a fair use basis. You will not incorporate in your documentary anything not licensed from us that we own. So you have to read the fine print of archive licenses to see if that's in there. If that's not in there, there's nothing in the law that prevents one from licensing some material from an archive and using other material on a fair use basis, except you can't get the fair use material from the archive. If you rely on an archive and get the benefit of the services provided by that archive to either search for material or to supply good high-res material to you, you can't then say, aha, I'm now going to use just a small portion of what you gave me and call it fair use. That would not be fair. And fair use, true to its name, requires fairness on the part of the producer too.
And
Bad community relations. Very bad community relations to double deal like that. And when the next time you have to go back to that archive, you may not have a very warm conversation. Relationships are important with archives.
And Stephanie has a follow-up here. Some archives, most recently ABC, have gotten restrictive on their use of on-air talent. They either restrict non-Disney productions from using their materials or make the price so restrictive it is hard to use. I'm curious how the legal community is able to deal with this increasing issue on branded content and how you advise filmmakers that are running into these issues.
Well, remember there are three categories for use of third-party material. The first category is license it, second category is fair use, third category is infringement. And you want to avoid infringement. So if you can't rely on fair use because of the nature of the documentary you're doing, well, that's left to you as license. And if the terms of a license being offered by the owner of copyright are onerous or simply don't fit your vision for your documentary, then you've got no license, you want to avoid infringement, all that's left is fair use. And that might mean that your documentary is not going to be quite what you envisioned. You can still probably convey the same information, but it won't be conveyed in the same way. You'll be using less, and it'll have to comply with fair use standards.
From Aaron Weisblatt, for a concert documentary film with multiple stars, have you ever heard of, and is it appropriate to license their songs under rules of most favored nations?
Well, that's not so much a copyright question. That's more of a contract strategy question, and that certainly does, in many instances, make a negotiation overall more simple. You sometimes hit a brick wall, though, if one of those performers thinks he or she is more valuable than anybody else.
Are releases, this is from Jocelyn Ford, are releases required or advisable for individuals filmed in a generic crowd scene in a public space, for example, in a park?
If you have people in a public space and they're incidental to your film, you're not showing them in close-up, they're part of the background, they're part of the crowd, releases are not necessary. And in fact, practically speaking, I don't really know how you get them if you're shooting a crowd scene. If you're doing close-ups, particularly of children, even if they're shot in a public space, I think getting releases is a smart thing to do.
This is from Alexis Bowling. What are the best practices for documentary filmmakers taking a film out of post-production through to a successful sale? Specifically, who do they need to assemble for their legal and business team to help them? What are the key roles on this team? So I think this is a big question. I think we're going to cover some of this next week as well. But I guess in terms of the legal team, who would you recommend getting on your team legally and at what point?
Well, my view with respect to documentary making is that it's good to have somebody on your legal team right from the start. You don't necessarily have to have that person involved every minute, but I think it's very helpful to get your orientation from the start so that you don't make mistakes. You don't build on some set of expectations that really can't be met from a legal standpoint. Then you get to the rough cut, and then you need a lawyer for most documentaries to review them for purposes of defamation, copyright, fair use, and privacy issues. And beyond that, you move into distribution. Well, actually, you hit the errors and omissions application form first, and then you move into distribution. And lawyers, needless to say, can help with contracts of all sort, and distribution agreements is one of those sorts. It's I think difficult for most people who aren't lawyers to understand distribution agreements.
So relating to E&O insurance, it's sometimes a very good idea to wait until you have a distribution deal, because different distributors have different requirements for E&O minimums. So they have certain policy requirements. And so once you know what that distributor's requirement is, then you'll be able to get the appropriate coverage, one that's right for that distributor.
We have a question from Juliana Penaranda Loftus. How about if you're in a war zone situation and someone gives you his or her testimony and the filmmaker didn't get the chance to get the appearance release?
So you're interviewing a dying person or somebody who you can find later on? Let's assume a dying person. Well, law isn't that solicitous of the rights of the deceased, either in connection with defamation or, for that matter, rights of privacy and publicity. So that doesn't raise a great concern for me.
We have a question from Brad Hamilton. You mentioned legal issues related to defamatory material. As a journalist, I found that one of the best defenses to being sued is aggressively attempting to get a full response from the person or company who is the subject of the negative characterization. Is the same concept applicable to documentary as far as increasing one's protection should there be an error or omission in the film?
That's a very good point. And it goes back to what I said about applying a common sense set of criteria when you ask and answer the question, how much corroboration do I need? And one of those common sense criteria is, have you asked the person or the entity being defamed what their view of things is? So that's one answer from a legal perspective. Your defense is improved if you've not overlooked obvious sources of questioning. The other aspect of that question, I think, is a more practical question, is a company that's had its opportunity to tell its side of the story, or at least give its spin to the story, less likely to be upset than a company that hasn't been given that opportunity? The answer is yes. That company that's been left out of the equation is more likely to be upset.
We have one, I think this is the final question we have time for, from Nancy Hammond. When filming in a public space where children will be present, such as an event, is it sufficient to post a notice at the door or on the event ticket stating that filming will be taking place?
It's better than nothing. And if you're shooting people from a distance, or you're shooting people who just appear incidentally and aren't shown as the focus of a shot, that's relatively safe. So would be not having any release at all, or not having any sign posted. But one thing that's useful in auditoriums or arenas or things of that nature is to post signs like that, so that so that people can't say that they were unaware of the fact that it was being shot and the purpose for which those shots would be put. What happened to
I think
Kirk?
that wraps.
One question. Kirk was going to.
Please. Let's go back to
Kirk
Kirk.
Schroeder was going to
Oh, yes.
clarify his question.
Yeah.
Let's
Thank
see.
you for remembering that.
I don't see that Kirk has, but maybe Kirk is your, oh, for a fair, oh, there we are.
Yeah.
For a fair use of a specific clip, like the network wants the attorney to opine on a specific clip regarding fair use. They're going beyond an E&O policy.
That's the network. I'm sorry. The network is asking for that opinion, or the insurer is asking for that opinion. Well, I'll answer both. The insurer is going to ask for every for one's opinion of every fair use. Ordinarily, lawyers are called upon to write opinion letters that address every item of fair use, and my general practice is to attach a list of them and where they're located by time code within the program. With respect to a network being a little skeptical of a fair use, that's sometimes a give and take discussion, and where it ends up more often than not is if it really is a fair use, if there's a good legal basis behind it, even if the network is somewhat skeptical, or the platform, you often get to a point where the network says, well, remember, you've signed an agreement where you, the producer, are ultimately going to indemnify us. So that if you're wrong, it's on you, not on us. But that's a discussion that you have. And I've never seen an instance where a network didn't come around and accept that something I thought was a fair use was a fair use, or wasn't a fair use.
So it's sometimes it's not a hard and fast black and white analysis, but it's a conversation, and usually the people at the network or studio are sophisticated enough to have a educated conversation where they're just looking for assurance.
Last question from Daria Price. Any situation in which we have two documentaries about the same subject, neither with any exclusivity, Doc 1 is in production years earlier, Doc 2 goes into production fully aware of Doc 1 and contacts producers of Doc 1, then proceeds and uses at least 6 of the same participants in interviews, but also other interviews? Would there be any issue of infringement, the second and latter doc infringing on the first?
There could be at some point such a similarity of elements that copyright would come to the rescue. But that would not be a common result, because remember, copyright does not protect ideas. And if the same idea is being explored in 2 documentaries, particularly if there are a set of interviewees that simply know the most about that particular issue, I don't think copyright's going to protect that. Unless, of course, all the questions are the same and the answers are similar. You can get closer and closer to a point where copyright might step in, but it doesn't protect ideas.
Well, Bel, thank you for hosting this, and of course, Dan, thank you for being my co-host. This has been a
Same to you, man. This was awesome.
Yeah, really enjoyed it. Very valuable discussion. Thank you so much, Neil Rosini. It's great to have your expertise in these important answering these important questions. We certainly had a lot of very good questions tonight from our attendees. Next week, we're very fortunate in our 4th and final session. We're focusing on marketing and distribution matters, and we have an expert in the arena, David Dinerstein, who'll be around. I think you popped in tonight for a visit, but David has been a studio executive and marketing executive for some of the biggest entities in the film business, and so I hope that our attendees will be loaded for bear, and we'll have some questions for David in this very dynamic marketplace. It'll be good to pick his brain about marketing and distribution matters. So without further ado, just thank you all for attending. We'll see you next Monday night, the fourth and final, and be well, stay safe.